Welcome to this week's edition of the Life and Legacy Show, sponsored by the Sechler Law Firm, where great families make great estate plans. My name is Tim Sechler. I am the host of this show, and I am the proud owner of the Sechler Law Firm, an estate and elder law firm assisting Western Pennsylvania. Main office is in Cranberry Township. We also have offices in Newcastle and Somerset, and have been able to help folks all up and down the western part of the state. And if you're new to this show, I use this show as an opportunity to do some education, because I, in my field, see people making mistakes day in, day out. And what I want to do is give you the information I think you need so that you are well equipped to make good estate planning decisions. I hope you find the show educational. I hope you find it a little bit entertaining. But what you should not consider it to be is legal advice. You should not make any legal decisions based on what you hear on this or any other radio show. I am doing this for some education and information, but in doing these shows, it can be really tricky to discuss all of the various factors that may impact your situation. And so you can't make decisions until somebody that really knows what they're doing analyzes your situation. This week's episode, I'm going to talk to you about a thing that we hear a lot of questions about here in the law firm, and that is death taxes. We're going to talk about a couple of different taxes that you should probably be thinking about as you're contemplating retirement and contemplating what happens when I pass away, and I don't want to give too much to Uncle Sam. And what can I do to protect myself? What can I do to protect my legacy and my kids from getting smoked on these various taxes? Before we get into the sort of the heart of the thing here, I just want to remind you that you can find out all of this information by joining us at one of our upcoming workshops. You can find our workshops at SechlerLawFirm.com, SECHLER lawfirm.com. And during the workshop, we tell you all about the differences in different types of wills and trusts and why people use certain types of trusts. And then what are the different issues that we want to talk about? It seems to me most people want to accomplish really the same things. I worked hard for some savings. I want to make sure that I get the savings to my kids or to whomever, I find important. I don't want to lose it to long-term care costs on my way out. I want to be smart about taxes. I want to make it relatively easy on the people around me. I don't want to be a burden. And these relatively simple goals in the legal system that we have can require sometimes kind of complicated considerations, drafting, estate planning, using different types of investment tools. And so to accomplish these objectives, we really have to talk about it. And one of the things that pretty much to every single client I think that I've ever worked with has had the concern about being smart about taxes, right? And we're not avoiding taxes, we're not evading taxes, but if there are techniques and strategies we can employ that my kids end up getting more of an inheritance in a legal way than Uncle Sam, well, then I'd rather my kids to have it, because I don't like the way these guys are spending our money, right? And so there's a couple of different types of taxes, but it's a part of a larger context that you can find out by coming to one of our upcoming workshops. And you can find those at SechlerLawFirm.com, SECHLER lawfirm.com, or by calling 724-546-4227. And during the workshop, we'll talk to you about all these different things. So let's talk about taxes. There's this kind of common knowledge amongst retirees and seniors that they come into the office that there's this big tax problem when people pass away. And here's the thing to understand is, there are taxes that we have to consider, but the big tax problem probably isn't as big as what most people make it out to be. In some historical context, there's several taxes we're going to talk about, at least four. We're going to talk about the federal estate tax. We're going to talk about Pennsylvania's inheritance tax. I want to talk to you about capital gains taxes, and then we're going to talk about this thing called the Secure Act and how it impacts your retirement accounts. Okay. Now, for some historical context, when most people are thinking about big death taxes, what they're really thinking about is the federal estate tax. All right. So the U.S. government has an estate tax. A decade or two ago, they unified it with the gift tax. And what this is, it's essentially a transfer tax. If you give away too much money, the IRS starts taxing you on it. They don't care really if you give it away during your life or upon your death. If you give away too much, they're going to tax you on those gifts. All right, and this tax doesn't apply in the way that it used to apply. But when it did apply, this sucker is a heavy hitter. Near 40% of the money that was subject to the tax would be hit. So, if I were over the exemptions and I had a $1 million estate and I was over the exemptions, my family could lose $400,000. And so lots of people, everybody knows somebody that lost a bunch of money to this tax. And from a historical standpoint, back in like the 1980s and 90s, lots of people were passing away and owed a federal estate tax because the lifetime exemptions used to be really low, right? And so now those exemptions are a lot higher, and this tax applies to a much smaller percentage of the population. But I do want to tackle first gifting, right? Because everybody knows that there's only so much money you can give away in a given year. And this is what we call the annual exclusion from the unified federal gift and estate tax, the annual exclusion. And in 2022, the figure is $16,000. So I can give anyone and everyone $16,000 a year, and I don't even have to tell the IRS that we did it, right? I can give my kids $16,000 each. I could give my brother $16,000, and we don't have to tell the IRS that we did it. If I go over $16,000, now I have to file a federal estate tax return. So there is this conception out there that you can only give away $16,000 a year. But see, here's what happens. If you give away more than $16,000, in addition to that annual exclusion, you also have a lifetime exemption from this tax. So while you go over 16 grand, you have to file a gift tax return. There's still going to be a zero at the bottom of the return. There's going to be no tax due because we all currently have a lifetime exemption of around $12 million that we can give away during our life or a death. And if you're married, that's $24 million for the married couple. And very small percentage of the population is really worried about $24 million. So let's just assume a large percentage of my audience doesn't have that problem. So if we're really not worried about the $24 million, then there's no tax, right? Well, no, not during the gift tax, right? So like if I would give away $50,000 this year, I have to file a gift tax return, and they're going to subtract that amount from my lifetime exemption of $12 million, right? So I still have an $11,950,000 lifetime exemption, right? Now, but here's the thing. Most people if the exemptions stay where they are going to pass away without a federally taxable estate, and we're never going to pay this tax. Right? However, there was a time not so long ago when that lifetime exemption, currently sitting at $12 million, used to be a lot lower. So in the 1990s, it was below $700,000. And if you count the value of your house and a life insurance contract and a retirement account, there's a lot of people that get to $700,000. A lot of school teachers can get to $700,000. A lot of people that we don't consider to be in jobs that make people extremely wealthy, a lot of people would still get to $700,000, right? And so there used to be a very large percentage of the population that would have to pay a federal estate tax, and everybody knew somebody that got dinged in the 90s. And when I am talking to this, oh, my grandma lost X dollars to the government, but it hasn't really been the case since the second Bush administration. And what happened was George W. Bush put the thing at $5 million. The Obama administration left it there. And then the Trump administration doubled it. And so when it was indexed for inflation, it got to $12 million. In 2026, if nothing else happens, if they don't change this law ahead of time, they're going to drop the thing down to about $6 million. Now, at $6 million, still 99% of the population does not have a federal estate tax, but some people do, and so then you got to be cognizant of that. And for a married couple, it would be $6 million each. Still, most people aren't going to pay a federal estate tax. There have been some proposals with some of these massive spending bills that Congress was debating here at the end of 2021, and it's kind of hit the back burner here in the beginning of 2022. There were some proposals to pay for some of that spending through lowering the exemption earlier. I think the lowest proposal that we saw was $3.5 million as a lifetime exemption. If I were a betting man, it's going to be around $5-6 million. They'll either, in my opinion, they're probably not going to change it and in 2026 it's going to go to $6 million. If they do change it, I kind of think it'll be around the $5-6 million number. There seems to be some bipartisan support for that. Call me cynical. Most of these senators end up wealthy by the time they pass away, and they don't want to pay the tax either. So I still think we're going to have relatively healthy lifetime exemptions, and so the federal estate tax is probably not that big of a deal for most people listening to the show. Well, there's the good news, right? We don't have to worry about the big 40% tax, most of us. But let's talk about Pennsylvania's inheritance tax. Now, the Commonwealth of Pennsylvania has a death tax, and it's technically an inheritance tax, which means it is technically owed by the people who inherit the money, though oftentimes it'll be paid by the estate. And this tax applies, there's only very, very, very small exemptions that sometimes don't even apply. And so the Pennsylvania inheritance tax, the rate of tax that is due is dependent upon the relationship you have to the person who passed away. So when someone passes away and the money is going to a nonprofit, then there's no tax. If I pass away and leave it to my spouse, there's technically a tax, but it's at 0%, right? So there's no tax. If, however, I leave money to a lineal descendant, my kids or grandkids, or if I leave money to a lineal ascendant, like if I leave money to my parents, the tax rate is 4.5%. Now, let's assume that people that are listening to the show, if you have kids, that's probably where you want to send the money. And there are exemptions for minor children and different things. But if I pass away and I have some money and it's going to my adult child and my child is going to pay a 4.5% tax, okay, that stinks. But if Johnny's going to inherit $100,000, Johnny can take 95.5. I'm not going to rearrange my world to save him 4.5%. And for most people, I think that's accurate thinking. I think that we're probably just going to pay this tax. With my clients, I call it the mosquito tax, right? Because a tax at 4.5% on my money when I pass away at some time in the future that we don't even know right now. Well, look, that's annoying. I don't like it, but I'm also not going to take massive action to avoid it. So it's kind of like a mosquito buzzing around, right? Now, there are ways to avoid the tax if you really wanted to, but most of them involve giving up control of your money, and it's really hard for me to advise clients to give up control of their money to save Johnny 4.5%. And so most of the time people just pay this tax, right? And so now let's talk about the other couple of rates that could apply. If you leave money to a sibling, that's 12%. Okay. If you leave money to really anyone else, nieces, nephews, friends, neighbors, domestic partners, if you leave money to anyone that is not otherwise in the other classes, it's a 15% tax. Now, 15% tax is a pretty heavy hit. So if I am in a situation where I don't have kids and I'm not married and I'm going to leave money to a nephew, well, then if I have, he's going to pay a 15% tax, and I don't like that. But at the same time, I'm probably not going to give up control of my money to save my nephew 15%, and so we're probably just going to pay this tax. And so that's sort of my take on the inheritance tax. And we talk about this in greater detail at our workshops, which you ought to check out. They fill up fast, so you got to go on and register at sechlerlawfirm.com, SECHLER lawfirm.com. And if you go to the workshops tab, you'll find the upcoming workshop dates. Most of them are right in our office in Cranberry. We occasionally hold them on the road in Newcastle and other places. So you could check out the workshop. But I think you'll find it educational. We try to keep it light and funny, and just get you the information you need to know. So really low pressure, but they do fill up. And so don't wait until the day before to try to register. It's probably going to be full at that point. So go ahead and register. Go to sechlerlawfirm.com, SECHLER lawfirm.com, and you'll learn all about wills and trusts and powers of attorney and these taxes we're talking about today. And you'll also learn about things like long-term care expenses and how to do asset protection work and how to protect your kids' inheritances from their future divorcee. What we do around here is what I really want is you to accomplish your goals, but most people tend to have the same goals. I want the money to get to my family, not to the government, not to some nursing home. I want the money when it gets to my kids to be managed responsibly. I don't want my kid to lose the money as soon as he gets an inheritance to like a divorce or a lawsuit. I don't want medical expenses creeping in. I just want to be smart and do the best that I can do to transfer the nest egg that I have accumulated to the people I love. And that's what we do here. And we're going to have some very honest conversations with you about your goals, and we're going to talk to you about what would happen if you would get sick, and what would happen with you, what would happen with the stuff, and who can make the decisions if you can't due to a stroke or some incapacity. And we're going to talk to you about what happens with your stuff when you pass away. And I know that these are not comfortable conversations, but the fact that you don't want to have the conversation does not change the fact that you will ultimately have some sort of a health issue, right? And so when we ultimately have these health issues, there's two ways to go into it. One is chaos, because we never did any plans. Two is, okay, it's unfortunate that Dad got sick, but we planned for this. We know how to respond to it from a financial standpoint. We know how we're going to get our care. We know how we're going to pay for it, and now we can focus on being a good child, a good spouse to Dad that's in the nursing home, rather than stressing out about the money all the time. And so I encourage you to put some time thinking about this. Come get some education. Most people spend more time planning a vacation than they do planning how they're going to transfer their entire life's work to their kids. And the result of that is we see a lot of mistakes. And so our job is to try to help you not make those mistakes. Let's talk about, getting back to the subject of today's show is taxes. Let's talk about another one called the capital gains tax. And the capital gains tax, it's technically an income tax, not a death tax, but your eventual death does impact how this thing works. And so the capital gains tax is a tax that is due upon the sale of an asset that has grown in value. Now, let's say I own a piece of real estate that I bought in Cranberry Township in 1985, right? And then Cranberry blew up like Cranberry did. And so I bought that piece of property for $50,000 way back when, and now the thing is worth $300,000. This isn't true, by the way, it's a hypothetical. So let's say that now I bought it for 50, it's worth 300, I have a capital gain of what? $250,000. Now, if I sold that property, I could have to recognize a capital gains tax, and combined federal and state capital gains tax could be as high as like 18%. So 18% on $250,000 is high $40,000 range, almost $50,000. So now I'm going to pay this tax. Okay. Now, here's where people make a mistake. One thing to understand is your primary residence, the sale of your primary residence is largely exempt from this capital gains tax. Okay, so that's helpful, because for a lot of families, the biggest asset that you own that has grown in value is probably your primary residence. And if you decided to sell that to move to Florida, they don't hit you for the tax. I mean, there are some limitations to this, but most people aren't going to pay any capital gains tax on the sale of the house. But if it were not the primary residence, if it were second property, or let's say it was like a stock and I sold it, well, now we're going to have a capital gains tax. All right? And here's where people make mistakes. We have people that come into the office and ask us to transfer their primary residence to their kid's name. And the reason they want to give their house to their kids, there's really two reasons. One is taxes, and then the second is they want to protect it from a nursing home. Well, okay. Let's talk about taxes. Like I just described in the show, we don't really have a federal estate tax anymore for most people. So they want to transfer the house because they're concerned about like some 40% death tax that doesn't apply anymore. What we're really talking about is a 4.5% death tax, and when I explain that, well, it doesn't sound so painful, right? The second reason is they want to protect it from the nursing home. Fine. But here's what you give up. What happens is, if Dad owns that piece of property, he bought it for $50,000 and it's now worth $300,000. If it's his primary residence and he sells it, he's probably not going to pay any capital gains tax. If, however, he transfers the house to his daughter, and then a couple of years later, Dad needs to move to, say, a personal care home, and we want to sell the house to come up with the cash to pay the bill at the personal care home. Well, now it's the daughter selling the house, and the daughter, it's not her primary residence. So she's going to have to recognize a $250,000 capital gain on the sale of that property, and she's going to lose almost $50,000 in capital gains tax. If we had just left it in Dad's social security number, no tax. Move it to the kid, tax. So remember, Dad was trying to be smart about taxes, and he actually made a $50,000 tax mistake. this is why we use trust for that situation. So people that want to protect assets from the nursing home and be smart about taxes, there's a much smarter way to do it with a thing called an asset protection trust, which we talk a lot about in our workshop. But the thing to remember, and there's one more thing to remember about capital gains tax, and that is we currently have this thing called stepped up tax basis when you pass away. So let's say that dad had the house, and when he passes away, rather than giving it to his daughter during his life, let's say that dad instead left it to her when he passes away. She inherits it rather than receive it as a lifetime gift. Right? Well, under the law, we have this thing called stepped up basis, which means she doesn't own it for what dad owned it for. She now owns it for the value of the house on the date of dad's death, which is $300,000. So then she is free to sell the house for $300,000. So she owns it for $300,000, she sells it for $300,000. She doesn't have to recognize a gain, and we have completely avoided the capital gains tax on that appreciated property, right? Great, we save $50,000. Now, yes, we would have left it exposed to Pennsylvania's inheritance tax because she inherited it. So we're paying 4.5% on the $300,000 home, okay? But no, look, if that's what's that, 13.5 or so, I'd rather pay $13,000 in inheritance tax than $50,000 in capital gains tax. And so be very, very careful with this transferring assets to the kids thing. And if you want to protect your assets and if you want to be smart, get legal advice. And most of the people that I know that are doing this, like we do it, we're going to talk to you about using trust to protect your assets rather than these more simple transfers, because it tends to be that this stuff can be pretty complicated. Look, if you've listened to this episode and you don't find this stuff complicated, then you're a smarter person than I am. But it tends to be that complicated problems rarely have simple solutions, right? And just giving the house to the kids is not the thing that is in most people's best interest. And so we have to educate ourselves. We have to get a little bit smarter about this. Now, the fourth tax I'm going to talk to you about, and I'm running out of time, and this is a hard one to get to, is this thing called the Secure Act that impacts your retirement accounts, IRAs, 401ks, 403bs, and the like. It used to be the case that if you would pass away and leave that money to your kids could take that and take what was called an inherited IRA, meaning dad's retirement account could be daughter's retirement account, and then she could spend that money through her retirement years. Since 2020, when this thing was approved called the Secure Act, now all of the IRA money has to be paid out in the first 10 years, right? So I want to point this out to you for two reasons. One, your kids no longer get tax deferred growth, and we did an episode just on the Secure Act not too long ago, so go listen to that if you have more questions about it. You can find it on Apple iTunes or Spotify. But it also matters because if you pass away and your daughter is 55 years old, your daughter is probably still working, right? Which means she's already in a high income tax bracket, and now we have to pull all the money out of your retirement account and pay income taxes on that during the first 10 years, which means she's going to get smoked on income taxes. And so this is a major change in the law. I personally look at it as a new death tax on the middle class, because middle class folks are the ones with retirement accounts. And though technically this is not a death tax, technically it's an income tax, it is income tax that is due within a defined period of time after somebody passes away because they passed away. And that sounds to me like an awful lot like a death tax on the middle class. So we've got this situation where wealthy people really don't have a federal estate tax. They don't really have a death tax, and most of their money, if somebody has $10 million, most of that's not in a retirement account. So largely no death tax there. But for a person who has, say, $500,000, most of which is in a retirement account, well, that person, there's a tax that's due when they pass away. And that's just the nature of the world. Look, it's nothing against the wealthy guy. It's nothing against the guy that has less money. It's just the way that these rules work. And so your task is to understand how the rules work. And a great way to learn this stuff is to come to one of our upcoming workshops. There's lots of information on our website. You can listen to the past episodes. You can do all of this. Like my law firm, what we do is we just put out a ton of information that we hope you find it useful, and we hope you make good decisions. But I want to counsel you that you should be working with a qualified lawyer to help you figure this stuff out, because it's more complicated than you probably think. And there's different tools that you're probably not aware of that we can implement to help set up a good plan for your family. You can find out all about our workshops and how to register and how to get here at SechlerLawFirm.com, SECHLER lawfirm.com. Spend one evening with us, one afternoon with us, learn all about this stuff, and then we can put together a really good plan for you. After the workshop, we offer you free consultations. My law firm works 100% on flat fees with estate planning. And so it's really a situation where you can get the information you need, you know what it costs, and you can make good decisions. So my little disclaimer before we get off the show today, don't make any decisions based on what you hear on this or any other radio show. This is for your education and information. If you want to make changes to how your affairs are in order, you need to call a lawyer. We are available anytime at 724-841-1393 or SechlerLawFirm.com. Thanks for listening.